You know that feeling, right? That not in your stomach when you're facing off against a giant.
Yeah, like David versus Goliath, but maybe in a courtroom.
Exactly. Maybe it's a huge bank or, an insurance company, some big financial institution,
Hmm.
and you're just one person, or maybe a small business, or a family farm.
How do you possibly get a fair shake in that kind of situation? It feels impossible sometimes.
It really does. And that feeling, well, it zeroes in on a core principle of justice, doesn't it? Ensuring fairness when people are actually in court.
Absolutely. Fairness is key.
And today, that's what we're digging into. Fairness in legal proceedings, sometimes called equality of arms.
Right. And we're going to unpack a really interesting kind of concrete proposal aimed at this imbalance. It's outlined in the source material we've been looking at.
Yeah, something called the Financial Services Law Force, or FSLF for short.
So our mission for this deep dive is basically to take this specific document, the one laying out the FSLF proposal, and connecting it to fairness for consumers, small businesses, farmers dealing with these big institutions.
And pull out the important bits.
Exactly. Pull out the crucial nuggets. We want to help you understand what this proposed force is, how it's supposed to work according to this source, and, well, why it matters in this whole equality of arms discussion.
And it's all based on the details right here in this document we're diving into.
Yep.
So let's start with that fundamental concept you mentioned. What exactly does equality of arms mean, legally speaking, based on what our source tells us?
Okay, let's unpack that. The source actually quotes the Australian Attorney General explaining it. At its heart, it's really about ensuring a fair hearing,
A fair hearing. Okay.
which means the interests of everyone involved have to be recognized. So, the accused, the victim, the community in a criminal case.
Or all the parties in a civil case.
Right. Everyone's interests get a look in. But the really critical part, the actual equality of arms bit, is that all parties must have a reasonable opportunity to present their case.
A reasonable chance.
Yes, and crucially, under conditions that don't put them at a disadvantage compared to the others involved.
Ah, okay. Conditions that don't sort of stack the deck against you. That makes intuitive sense. Does the source give a clear example of what that kind of disadvantage looks like?
It does, yeah. And it's a good one. The document mentions a finding by the UN Human Rights Committee.
Okay.
They found this principle was violated in a situation where the prosecution had a right to appeal a decision.
Right.
But the accused person didn't have that same right.
Oh, I see. So it's not just about getting into court. It's about having access to the same kinds of legal tools once you're there.
Exactly.
If one side has something like an appeal right and the other just doesn't have it, well, that's a built-in disadvantage.
Precisely. The very structure of the process in that instance created an unfair playing field. That example really highlights the core problem equality of arms tries to fix.
And this is where the proposed financial services law force comes into play, right? How does the source link this FSLF idea to that bigger principle of fairness?
Well, the document describes the FSLF as a limited initiative. It's not being pitched as, a magic bullet for every legal inequality.
Limited how? Like who it covers?
Exactly. It would apply specifically to financial service provider, FSP consumers, small and medium-sized enterprises, SMEs, and farmers.
Okay, so targeted at individuals and smaller businesses who might clash legally with big financial players.
Correct. And there's another really key limitation here, according to the source.
Which is?
It applies only when an FSP initiates a legal instrument or action against those groups.
Ah, so if a consumer decides to sue the bank, for example, this FSLF doesn't kick in.
Nope. Not according to this proposal. It's only triggered when the FSP takes that first legal step.
That feels like a really critical detail. It's about responding when the entity with typically way more resources decides to start the legal fight.
That's the focus.
So, okay, an FSP initiates legal action against, say, a small business. How would this FSLF thing actually work then? How's it funded?
Right. This is where the proposal gets quite specific. The funding mechanism is directly tied to the FSP's decision to go to court.
Okay.
According to the source, right at the start of that action, the FSP would have to make a non-refundable contribution.
Non-refundable. So they don't get this money back. Ever.
That's what the document says, yeah. Non-refundable. And the amount, it's proposed to be pretty significant. It should be equivalent to the FSP's total internal and external legal budget or costs.
Wait, their total budget?
For that specific action they're initiating.
So, hold on. Whatever the FSP plans to spend on its own lawyers, internal and external, for that specific case, They have to put that exact same amount into this fund up front,
That's the mechanism described, yes.
and they don't get that upfront contribution back, even if they win.
Correct. That initial contribution is non-refundable. The source also says any escalation in the legal action, like adding new claims or making it much bigger, would mean further matching contributions from the FSP.
Wow. Okay. And the FSP can only get their own legal costs back the money they spent on their side if they win the case against the consumer or the SME.
Yes, that's the only way they recoup their own expenses.
So what's the purpose of this upfront non-refundable money then? Where does it go?
That's the crucial part. The source states it directly funds the proposed public, permanent, independent, specialist financial services law force.
So the FSP's choice to sue is the funding trigger, and it funds the defense for the party they're suing.
Exactly. But the FSLF itself wouldn't necessarily be like a whole new set of buildings and lawyers starting from zero.
Oh, how would it work then?
The proposal is that it would work by using, collaborating with, and funding the existing legal aid and community legal centers.
Oh, okay. So it injects resources and maybe specialist knowledge into the system that's already there trying to help people.
Precisely. And because they'd have this guaranteed funding and support, these centers could then offer what the source calls expert, timely, proportional, and equitable legal representation.
To those specific groups, consumers, SMEs, farmers, when they're on the receiving end of FSP-initiated legal action.
Right. The whole aim is to equip them so they can actually participate on a level playing field, to make equality of arms real in practice.
That directly tackles the problem by giving them the means, the resources, to make their case properly. Now, the document seems to anticipate some questions, like clarifying different scenarios. What about the other way around? If a consumer or SME takes an FSP to court, does the FSP still pay into the fund?
No. The source is very clear on that. Absolutely not.
Okay.
The initiative is designed only for when the FSP initiates.
Right, so it's specifically targeting that power dynamic when the bigger player decides to, pull the trigger on litigation.
Got it. What about things like IDR and EDR, the dispute resolution stuff that happens outside court? Does this FSLF replace those?
No, it wouldn't replace them. The document makes that clear. IDR is internal dispute resolution, EDR is external.
So those processes stay.
Yes, but the source suggests there'd be an interesting knock-on effect.
Like, because this proposal would mean equality of arms exists if things escalate to court, it's expected to give FSPs a much stronger added incentive to resolve disputes earlier through IDR and EDR.
Ah, so knowing the court option is now more balanced might make them try harder to settle things before it gets that far.
That's the argument presented in the source, yes. It suggests this could actually end up increasing the effectiveness of those existing dispute resolution systems.
Interesting. Okay, let's talk fairness. Is it actually fair to make the FSP pay for the other side's legal costs just because they initiated the lawsuit?
Well, the source tackles this argument head on. It points out that the decision to take a consumer, SME, or farmer to court rests entirely with the FSP.
They choose to do it.
They choose. And the argument is they could choose other paths. They could act more reasonably, maybe use alternative dispute resolution methods more effectively instead of just jumping straight to legal action.
And the source also stresses this isn't just some random fee, right? It's linked directly to their action.
Exactly. It's not an indiscriminate levy slapped on everyone. This FSLF cost only applies if an FSP chooses to use the courts this way. And the amount, remember, is described as proportionate. It mirrors their own planned spending for that specific case.
Okay, proportionate to their own action.
Yeah.
What about the bigger picture for FSTs? Could this just make litigation way too expensive for them overall?
The source acknowledges that, yeah, costs could potentially go up for FSPs that frequently take these groups to court.
Right.
But it also puts forward arguments for potential cost reductions.
Reductions, how? Where would savings come from?
Well, the source suggests a few things. Costs might decrease if FSPs are actually incentivized to use IDR and EDR better and fairer, meaning fewer court cases overall.
Okay, avoiding courts saves money.
Right. Also, maybe they'd make more frugal choices about their own external lawyers if they know they have to match the cost.
Interesting point.
And maybe court processes themselves become more efficient if the playing field is more level from the start.
So behavioral changes driven by this system might actually offset or even cut some costs down the line.
That's the potential dynamic the source presents. And importantly, beyond just the dollars and cents, the document really emphasizes that a key outcome is much greater fairness for the consumer.
Which is the whole point of equality of arms.
Exactly. And it also anticipates a big decrease in legacy cases. Those really drawn out, super expensive disputes that just drag on forever.
Yeah, those must cost a fortune.
Huge amounts. So avoiding those saves significant future costs.
So it's a balance. Potentially higher upfront costs for starting a case, but maybe savings later from better dispute resolution and fewer long, messy court battles.
That's the picture the source paints, yeah.
What about regulators, like ASIC or APRA here in Australia? How might this affect them?
The proposal suggests the FSLF, because it would be operating independently and right where the legal action happens, would be in a great position to spot systemic issues.
Systemic issues, like recurring problems.
Yeah, like patterns in how FSPs behave that keep leading to these legal fights. The FSLF could spot these problems early and independently.
And do what with that information?
Share it with the relevant regulator, like ASIC or APRA. This intelligence, the source suggests, could make the regulators more effective, maybe even reduce their workload and costs by flagging problems sooner.
Because they get this direct signal from the sort of coalface of legal action about potentially bad practices.
Right. A new independent channel for spotting risks.
Okay. And what about those legal aid and community legal centers, the ones the FSLF is meant to fund and work through? How does the source see this impacting them?
It paints a picture of a pretty significant positive transformation for them.
How so?
It suggests these organizations would finally be properly empowered to help all FSP consumers, SMEs, and farmers who are facing FSP-initiated legal action. They could provide help that's timely, proportional to the case, and genuinely equitable.
And the key reason for that empowerment is
The funding, the guaranteed funding, knowing the money will be there, but also having the expert knowledge, the support systems, the personnel needed to take on these often complex cases effectively.
so they wouldn't constantly be outdone by the FSP's massive legal budget.
That's the idea. It addresses that huge resource imbalance that often prevents them from going toe-to-toe right now.
Makes sense. Finally, governance. How does the source suggest this FSLF thing would actually be managed or overseen?
It proposes oversight by a board, and the makeup of that board is quite specific.
We'll be on it.
Representation from the federal government, consumer groups, legal aid groups, and community legal center groups.
Okay, so stakeholders focused on the public interest and consumer small entity side.
Right. And it's also very specific about who should not be on that board,
Oh.
who's excluded.
The source explicitly says no representation from FSPs themselves,
Well,
also no financial dispute mediators, FDM, no external dispute resolution bodies, EDR, no ASCA, that's the Australian Financial Complaints Authority, no QAIC, and no private law firms. Wow, quite a list of exclusions. What's the reason given for that?
the document says it's to prevent what it calls white anting and inappropriate external influence.
White anting, like undermining from within.
Seems to be the concern, yeah. The clear intention appears to be keeping the FSLF laser focused on its mission, advocating for those consumers, SMEs, and farmers, and protecting them from legal disadvantage without conflicting interests at the board level.
Interesting. Did it mention anything else about the structure?
Just briefly, it also mentions a separate idea for a public federal bar association, maybe to support the lawyers working within this public interest framework.
Okay, building out the professional side for these public legal practitioners.
Seems like it.
So let's pull back to the big picture then. This proposal we've unpacked from the source material, the FSLF, it's really a direct shot at putting equality of arms into practice in a very specific area.
Yeah, trying to level that legal playing field when big financial institutions decide to sue individuals or smaller entities.
And the core mechanism is making the initiator, the FSP, fund the defense, funneling that money through the existing legal aid and community legal center network.
It's a model that basically shifts the cost of fixing that power imbalance onto the party that sets the legal wheels in motion, theoretically leading to fairer outcomes, maybe changing behavior before things even get to court.
Right. So considering all the arguments laid out in the source about boosting fairness, potentially cutting down those really stubborn, costly legacy cases, maybe improving regulatory insight, what are the broader implications here? What happens in the system where the cost of starting a legal fight is directly tied to making sure the other side, the less powerful side, gets a fair fight too?
How might that fundamental shift in who pays and the incentives that creates really reshape how big organizations think about resolving conflicts in the first place?
Exactly. Something to really chew